Just one correction before we start. Ms. Tasneem Hussain will be my co-counsel for the appellant.
So who will be your co-counsel?
Ms. Tasneem Hussain will be the junior appellant.
Mr. Tasneem Hussain, right.
Yes.
Thank you, counsel. And are you ready to proceed?
Yes, we are.
And Mr. Philip, on behalf of yourself and Mr. Basiasefi, are you ready to proceed?
Oh, yes, Your Excellency, we are ready. We are very much ready to proceed.
Thank you so much. Well, in that case, in the absence of a court clerk, I call on for hearing the appeal in the Dubai International Finance Center courts, in the Digital Economy Court, the matter of Rani against Payne, where Mr. Payne is the appellant and Ms. Rani is the respondent. In those circumstances, I would call upon counsel for the appellant to open their appeal.
Thank you, Your Honor. Good morning and good afternoon, Your Honors. My name is Aisha
Sorry, I should make a disclosure, and that is that I have previously seen counsel for the appellant, one of the counsel for the appellant, Ms. Aisha Bashir. I have not seen Mr. Tasneem Hussain. He has not appeared in front of me before. I am confident that I can be impartial and independent in the hearing of this appeal, but it is right that I should A, make that disclosure, and B, invite both counsel to indicate whether they are happy for me to continue to sit as part of this appeal panel, or whether they would wish in the circumstances for me to recuse myself. Ms. Bashir, are you happy for me to act as part of the appeal panel?
Yes, Your Honor. Also,
and Mr. Sorry?
Just wanted to let you know, Ms. Tasneem Hussain is a woman.
Oh, sorry. It's right, Ms. Tasneem Hussain. I'm very much obliged for that correction. Thank you so much. Mr. Philip, are you happy for me to continue as part of the panel?
Oh, yes, Your Excellency. In fact, the respondents are very excited to have you as the judge to head this particular round.
You are free to change your mind as regards that statement. And I should apologize also before we get going for looking like something out of a Hitchcock horror movie, but it's backlit and it's rather light. It's rather dark in London. So I hope that as the sun comes up, I will look less like a warmed up corpse. But anyway, that's enough. Let's start the appeal hearing. Counsel for the appellant.
Good afternoon, Your Honors. My name is Aisha Bashir, and I am the senior appellant representing Mr. Liat Payne. My co-counsel is Tasneem Hussain, the junior appellant for Mr. Liat Payne, and we are representing Mr. Payne.
So come on, against... I will save that. I want to save that. Don't worry.
There's someone's got an open mic. Could we have all mics turned off apart from counsel addressing us, please?
We are representing Mr. Payne against Ms. Rani on appeal from the DEC. Your Honors, this is a case about a party who freely engaged in Caprica's speculation, a party who knew or ought to have known that letting a computer program commit her to an unlimited value of cryptocurrency purchase and having lost money as a result of her largesse now wants to void the contract whose formation she delegated to an algorithm. This is a case about a party who carelessly gambled and now wants to walk away from her losses by claiming she was mistaken when she speculated on a notoriously risky commodity. A party who was sophisticated enough to design an algorithm to trade, but now claims that she was not alive to the chance that the trading platform circumstances could change, resulting in her losses. and that this is sufficient to set aside the contract she is bound to. This case is simple. Just as contract law concepts of offer and acceptance are applied to algorithms, the common law concept that courts don't intervene to save parties from a bad bargain, either through errors of judgment or carelessness, applies. And that is the case here, a simple case of a bad bargain brought about by an algorithm due to respondents' carelessness in coding. Your Honors, we argue that the trial judge erred in applying Al-Khurafi versus Bank Sarasin in concluding that the DIFC court had jurisdiction over the claim by Ms. Razi against Mr. Payne, and we argue that the trial judge erred in concluding that it was sufficient for the purpose of satisfying Article 37(1)(a) of the DIFC contract law that Ms. Razi showed that a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that disputed trade was the result of an error. Your Honor, the facts of the case are as follows. The parties to this dispute are traders of cryptocurrency, which in this case were bought and sold on a platform called Clevity. The traders did not press buy and sell like you would on typical online shopping platforms, but instead, traders had set up programs to buy and sell for them using algorithms, so that the purchase and sale would happen with no further human involvement. Ms. Razi had a program called Alpha, which brought Yapo, a cryptocurrency, at the best available price. Mr. Payne had a program called Beta, which sold cryptocurrency based on the average price on the platform, unless no one was selling, in which case it sold for a much higher price. On the 10th of June, a problem occurred for 30 minutes, and the platform, which mistakenly excluded all traders except Ms. Razi and Mr. Payne. And as a result, Ms. Razi's program bought the only Yapo available, which was Mr. Payne's program, selling at 250 times the prevailing market price. These are the disputed trades, and both parties were asleep when this happened. I will be arguing the jurisdiction, whether the DIFC has jurisdiction. Your Honor, we argue that the DIFC does not have jurisdiction over this case. Firstly, Your Honor, a note itself, during the application of Al-Khurafi versus Bank Sarasin, during the application in the first instance, the courts concluded that the DIFC had jurisdiction. However, we argue that a note does not allow for an extension of legal entity to exercise exclusive jurisdiction. In Al-Khurafi, it was stated that a branch was not a separate entity, but an extension of the legal entity. The place of jurisdiction for proceedings in that case were extended.
Counsel, apologies for the interruption, but just to be clear, is in question here that Clevity had a branch in the DFC?
In the sense, yes. We are arguing that the Clevity did not have a branch in the DIFC and that it should not have extended onto them. But the DIFC.
Thank you, Counsel. So you're not making argument on the basis of paragraph B of Article 5, which is about a contract performed or
we are also making an argument based on that as well. We are making an argument based on the geographical location as well as the performance or a commercial activity within the DIFC.
Thank you, Counsel.
Thank you, Your Honor. So, with regard to the actual geographical jurisdiction, the assumption is that the entity will be sued or sue in the place of its jurisdiction. In Al-Khurafi and Sarasin, which was applied in that case, in the first instance case, it was accepted that there was a branch within the DIFC, and furthermore, the claimant in that case had participated by telephone, email, and fax through the branch within the DIFC and had sent instructions for an investment through Sarasin Dubai to the main branch. The contract was therefore partly performed within the DIFC and the branch was present within the DIFC. However, Your Honors, We argue that this principle should not be applied to our case, where the entity did not have any branch in said jurisdiction, but instead had nodes, which, although in cryptocurrency nodes are used for a lot of activities, for instance, acceptance and rejection of transfers, it is still an infrastructural equipment. It is not per se an extension of Clevity itself. You would not be expected to sue or be sued by a node itself. And there is nothing to evidence that the particular transaction that we are currently disputing occurred in that node itself.
But counsel, don't we have to look at the principle of consensus mechanism here? And but for consensus, there would be no trade, and the consensus requires the consent of all of the nodes, including the node in the DIFC. Why does that not establish jurisdiction?
Because, Your Honor, there are hundreds of nodes, and the likelihood that it would be that particular node that would have that much of an impact that the commercial activity would affect it or have relations to DIFC activities is very unlikely. If we were to take...
It isn't that one node has a disproportionate effect. It is that each of the nodes has a similar effect, but without all of them consenting in the consensus mechanism, there's no trade. So why wouldn't there be at least potentially 100 or more jurisdictions? But it happens to be that the DIFC has been chosen.
With regard to that, Your Honor, if we were to accept that in that circumstance, then the accepting nodes would then open it up to hundreds of jurisdictions in the same way. You would have claims from a node all over the world, and then an exercising jurisdiction or exclusive jurisdiction, you would come to the argument that it would then open up to too many avenues, and every single one could bring in the claims. Furthermore, Your Honor, we argue with regard to that neither parties were members of the DIFC, nor was Clevity itself based within the DIFC. In common law courts, we understand that it has general jurisdiction. That is, they have authority to hear any dispute, the extent that it has been given by the Constitution and the legislation of the sovereign it represents, except those forbidden by the law, of course. Some states refuse subject matter jurisdiction for cases that do not involve its citizens or do not occur in its territories. In the case of Mansfield Co. versus Swan, the power to declare the law is known as the jurisdiction, and no claim may proceed without it, even if both parties wish to adopt it. In Mansfield versus Swan, the claimants had two offices in Ohio and Michigan, and filed an action in Ohio State Court seeking to recover damages against the defendant's railroad company and another entity for alleged breaches of a contract regarding construction of a railroad. Claiming that the partners were not citizens of Ohio, the railroad company requested the case be transferred from state to a court to federal court, and in its ruling, the court found that the Federal Circuit Court lacked jurisdiction in the case because the railroad company was not entitled to removal, because the railroad company's pleadings did not affirmatively state the citizenship of one of the partners. According to the removal petition, the partner and the railroad company were citizens of the same state at the time the action was first brought in the state court, and it did not affirmatively appear that he was a citizen of any other state at the time of the removal. Similarly, in our case...
Counsel, sorry if I interrupt you. This U.S. case that you are citing, was it a federal or state case?
The case was a federal case.
Federal. So in my understanding, cases in the United States are federal cases are based on diversity of citizenship. So a requirement, I believe that was the case in Mansfield, is that both parties reside in a different state of the United States, or one of them resides outside the United States, which is not really relevant here because the GCC is not a federation. Dubai, the DSC and Dubai are two jurisdictions within one emirate. That's not a federal state. So why is that relevant here?
we are bringing in the effect of how common law jurisdictions would deal with difference in citizenship, and how in this case we had seen how when the courts found that they were both actually of the same, not of the same citizenship, that they referred it back to the Ohio courts. And in our instance, we are arguing that Mr. Liat Payne and Ms. Rajrani are both not members of the DIFC, and they do not reside in the DIFC.
Counsel, I think, in my view, there is no question that I think what you're saying here is that there is no scope to trigger paragraph A of Article 5, which is about civil commercial transactions involving a DFC body, establishment, or licensed DFC establishment. I don't think either party or the court for assistance addressed Article A. I think the battle here is on Article B. So I don't know what my colleagues' views are, but in my view, I think you should rather address Article B, which is where I think the battle is today on jurisdiction.
Yeah, agreed. Yeah, I agree. Yeah.
All right.
It's B actually.
Okay, of course, Your Honor. In that case, for the civil and commercial and the finalized, I can discuss that as well. In that case, I can bring it to our next argument, which is essentially that the commercial activities that triggered the action did not occur within the DIFC. And in that instance, we also bring forth regarding the aspect of the node that a crypto asset is property, and the lex situs, which is the law governing the property questions about an asset. For crypto assets, the place where the person or the company who owns or controls it is typically the rule taken is that it is the resident of that area. And in our instance, the company was not residing within the DIFC. The activity did not occur within the DIFC. There was no performance within the DIFC.
What company are you talking about? Are you talking about the parties, or you're talking about Clavity? What company you're talking about?
I'm talking about how the Clavity itself was not residing in the DIFC, despite the fact that it had a node there. It was simply
yes, counsel. But again, this would be relevant for paragraph A, which is about where a party resides. Paragraph B, it's about where a contract was promised, concluded, finalized, or performed. So what we would like to hear from you is why, even though the server was in the DFC, why you arguing that the contract was not performed or entered or concluded in the DSC.
Understood, Your Honor. For that, I would refer back to my very first argument, which was that the node itself, although each node does interact with each other, the contract itself, it is unlikely, if not impossible, to prove took place in that area at such an event that you could say that it had a substantial effect on the commercial activity carried out within the DIFC, or that the incident itself or the interaction that occurred would then give the DIFC jurisdiction over the claim arising from that incident, because to state that the contract occurred within the DIFC is very difficult, if not unlikely to prove. In the case of Al-Khurafi, it was very straightforward. They had those dealings through the branch within it. In our case, it is a server extension which has many nodes across the world, and to claim jurisdiction based on just a node would be very difficult.
Counsel, if nodes do not confer jurisdiction, which jurisdiction or jurisdictions do you say Ms. Rani should have brought her claim? Whether it's a good claim or a bad claim needn't be resolved for present purposes, but what jurisdiction or jurisdictions do you say would have been open to her if not the DIFC?
We believe, Your Honors, that better suited jurisdiction would be either where Clevity is based or the Dubai courts themselves.
Why the Dubai courts?
Because Ms. Rani is based in there and the losses felt from her transactions were felt within Dubai, not the DIFC.
But in my understanding, the other party was in Oman. So why Dubai and not Oman?
We believe that if Ms. Rani was bringing a claim forward, she would do it in a jurisdiction where she had felt the losses or where she would do it so. If she would wish to bring it to Oman, that would also be suitable to our client, as it would also make it easier for her to approach our client. However, we are amicable
So you're pleading forum non-convenience here?
Yes.
Okay, what is the standard for forum non-convenience?
For forum non-convenience, the international practice dictates that you would go towards the parties involved, so either side of them.
Council, I'm grateful, and I think I speak on behalf of my colleagues in saying that we have been a very interventionist panel. And for purpose of keeping time, I wonder if, although you doubtless have other arguments to develop, you could just summarize your arguments in no more than half a minute.
Of course. To conclude, we would say that the nodes operate at the same time, and resting the DIFC's jurisdiction on a transaction on a node is very difficult. We plead before your honors to hold a decision in the Court of Appeal and overrule the decision made in the courts of first instance. Thank you, your honors.
Counsel, thank you very much. And I think you indicated that your junior counsel would be following on the question of mistake. And I invite her to do so.
Thank you very much.
Excuse me, Your Excellencies.
Yes.
I have an observation. The rules and procedures for these proceedings clearly states that after the senior counsel for the appellants address the court, the next person in the line should be the senior counsel for the respondent.
Oh, I'm very happy to follow that course if you should wish. My apologies, and I should say that you will be given exactly the same amount of time as your opposing counsel. So you have, on my estimate, about 18 or 19 minutes. And I think you're on mute. Yeah.
Okay. Your Excellency, can you hear me? Can anyone hear me?
Yes, we can now.
Okay. Are we adopting the procedures, or we are making a difference in this particular proceeding?
No, you wish to. Well, if it's my error in relation to procedure, I'm happy to follow whatever is convenient.
It would be my wish that
I think counsel for the respondents is correct.
I'm obliged. Please, Mr. Phillips, please. My apologies.
Thank you, Excellency. My apologies for any inconvenience I might have caused you. So,
please, you can proceed.
Okay. May it please this court. Entering appearance is Katie Philip, senior counsel for the respondent. Your Excellencies, and the respondent shall be addressing this court on the two grounds that were distilled by the facts of this case. The first ground centers on the jurisdiction of the first instance court, and the second ground deals with mistakes. Before this court is the respondent's skeletal bundle filed and dated 4th day of November 2022, and the respondent shall be adopting and relying on all the facts stated therein, all the arguments canvassed therein, and as well all the prayers that were made, that were contained in the said skeletal bundle, particularly on the twin prayers that were made by the respondent, which is contained in page 5 of the respondent bundle, which is that the court should make a declaration that the decision of the trial court was not in error, it was correct. They were exercising their rightful jurisdiction. And the second prayer is that the appeal before this court should be dismissed with cost as lacking merit. In addressing this court on these issues, the senior counsel for the respondent, which is me in particular, I'll be utilizing 20 minutes of the allocated time. And my junior counsel shall be addressing this court on the second issue, and she will be taking 25 minutes because I'm made to believe that we have 45 minutes for our argument. She'll be utilizing the 25 minutes that is remaining. And with the kind permission of this court, I wish to go to the substance of ground one.
Sorry, Mr. Philip, could you, how long are you planning to address the court for?
20 minutes, Your Excellency.
And your co-counsel for how long?
25 minutes.
25?
Yes, Your Excellency.
Because my understanding had been that it was 15 minutes per counsel, but perhaps my co-judges can help me with regard to the rules.
I think it's 45 minutes per team. Let me just double check the rules, but I think that's my understanding. It's 45 minutes per team. And then, so basically they have been, pleading for senior counsel for appellant. Now we have senior counsel for respondent. Then senior appellant have a short rebuttal. Then will be turn of junior counsel for appellant. Then junior counsel for respondent, and again junior counsel for appellant who have can rebut.
Yeah. So basically, 45 minutes covers everything.
Well, my apologies if I cut Ms. Bashir off too early, but that's fine. Please continue.
Thank you, Excellency. Before going into the substance of my issue, I would love at this point to make some comments on the senior appellant's argument, which I considered very important that I make this comment before proceeding. I seek the permission of Your Excellency to proceed.
Yes, go ahead. Actually, we're very interested in this, given the structure of this moot. Basically, what we're expecting to hear from you now is a very long rebuttal to what the senior appellant said. So we'd like you to address those arguments.
Thank you, Excellency. The senior counsel for the appellant made mention of the fact that the node located within the DIFC is just a node, and as such, it cannot be even said to constitute a branch of the Clarity platform. However, she fails to understand the nature of that node as contained in paragraph 1 of the statement of fact, the moot problem. The paragraph 1 of the moot problem did not just refer to this node as a mere node. It refers to it as a distributed ledger node. It is not an ordinary node. It's a blockchain node. And the nature of node within a blockchain network, it's a special one. It's not like a network that has a server and other networks are peripheral. They are subservient to a server. This network doesn't have a server, and each node can rightly be said to contain all information contains in another node. That is why we have things like NFT having values, because all nodes within the network are like witnesses to what is happening in the network. So you cannot say what node A is privy to, node B is not privy to. So, and as such, the assumption that it is not the node that is contained within the jurisdiction of the DIFC court that was used for the said transaction is unfounded, because under a blockchain network, all the nodes in the network can rightly be said to be witnesses or can rightly be said to partake in a particular transaction. So any node can serve as the node that the transaction was carried out because the information or the transaction is contained in all the nodes. And with regards to her proposition that it is unethical for many courts to have jurisdiction, or for many countries to have jurisdiction with regards to the case, and we have cases flowing in. However, that is not a problem. That is, in fact, in the case of Lustin and Lloyd, Lustin and Lend, decided by the small case tribunal, the court is of the view that the DIFC court will have jurisdiction when the case before the court has been rejected by another court. That is to say, another court must have had the jurisdiction and they are rejecting the case, and the case is before the DIFC court, then the DIFC court will have jurisdiction. So many courts can have jurisdiction. However, if they fail to exercise that jurisdiction and the case is brought before the DIFC.
Sorry, Councillor, just to be clear, on what part of Article 5 of the Judicial Authority Law do you say that the DIFC court has jurisdiction?
Okay, my contention that the DIFC court have jurisdiction is premised on Article 5A1B of the Judicial Authority Law. That is my contention before this court. And,
so which part, specifically which part? Was this contract performed in the DIFC? Was this contract concluded in the DIFC? What happened?
And in my subsequent argument, I shall be proving before this court that the contract was concluded wholly within the jurisdiction of the DIFC court. However, assuming but not considering the said node was not the overall network of clevity that is located within the DIFC, the authority of Current Pipeworks SA and Barclays Bank decided by the Court of Appeal of the DIFC that when a company, a multinational company, has a branch within the DIFC and a transaction is concluded using that branch that is located within the DIFC court will have jurisdiction, irrespective of the fact that their headquarters is not located within the DIFC.
Was in that case the branch licensed in the DIFC or not?
Your Excellency, we are meant to restrict ourselves to Article 5A1B, and it's only
I know, but you're citing authority from this Court of Appeal, right? So from the DIFC Court of Appeal. So in that case that you are citing, you're talking about a branch, which suggests that the holding in that case related to an entity that was licensed in the DSC, and therefore there was an establishment for the purpose of paragraph A of Article 5.
Yes, Your Excellency.
So it's not relevant for Article B. Sorry, for paragraph B.
I don't get Your Excellency with regards to that.
Sorry, my question is, so you're talking about a case where there was a branch in the DSC, and on the basis that the branch was in the DSC, then the court had jurisdiction.
Your Excellency,
that reasoning hints to paragraph A, not paragraph B of Article 5.
Your Excellency?
Can you just gives us the facts of that case, the facts of this authority?
Okay, in the case of Lustin and Lend, Your Excellency, a company, a multinational company, was using its branch that is located within the DIFC to carry out a contract within the DIFC, and a contract was concluded, and the objection of the said company was that, okay, they are not located within the DIFC, their headquarters is not located within the DIFC, and as such, the DIFC court does not have jurisdiction. However, the small case tribunal was of the view that since the branch located within the DIFC was used to carry out the substantial part of the said transaction, the DIFC court will have jurisdiction, irrespective of the fact that the main company's branch is not located within the DIFC.
So,
yes, I think one of the things that the tribunal, the court, will have to grapple with is the fact that, unlike in Saracen, where Saracen was a party, Cleverty is not a party to this appeal. And we know that Ms. Rani is resident in onshore Dubai and Mr. Payne in Oman, and therefore neither of them plainly are parties within the context of Article 5A1A. So perhaps we can invite you just to go back to 5A1B, and with regard to a node, why should the court not simply say, well, the node is an instrument for recording the contract, not an instrument for making the contract? And if the node doesn't make the contract, how can it be said that the node is instrumental in concluding or finalizing or performing the contract, which is the obligations and requirements, at least in part, of Article 5A1B?
Thank you, Excellency, for this question. Well, Article 5A1B, particularly the B part of the said article, does not talk about the parties. It talks about the contract itself. The contract is concluded within the jurisdiction of the DIFC courts. So, and the Cleverty platform itself operates a distributed ledger with a node located within the DIFC courts. And these nodes enable every transaction to be carried out. That is the functions of these nodes. They help in concluding a said transaction. And it is this node that finalizes a transaction. So they are very instrumental with regards to any concluded contract within the platform. So that is why if a node should be located within the DIFC, it will give the DIFC court jurisdiction under Article 5A1B of Judicial Authority Law.
But the node is inanimate, and that's why I have difficulty conceptually with the node being somehow instrumental, to use your word and my word, instrumental in the conclusion of the contract. But maybe that's something that the court itself will just have to grapple with. We've explored that. Do continue, Mr. Philip.
Thank you, Excellency. And moving on to the substance of my argument, which is that whether the trial court in concluding that that because Cleverty operates a distributed ledger with a node located within the jurisdiction of the DIFC courts, the DIFC courts have jurisdiction to entertain the matter. My contention before this court will be that the trial court was right to have exercised jurisdiction over the matter, and that the appeal before this court is without merit and it should be dismissed with cost. I shall be premising this contention on two main standpoints. The first standpoint is that the node that is located within the jurisdiction of the DIFC court constitutes the overall Cleverty platform. And the second standpoint is that there is no clause excluding the jurisdiction of the DIFC court, and as such, relying on the authority of Lustin and Land, and as well Gavin and Geno, the DIFC court ordinarily will have jurisdiction by default over the said matter.
I have a question here, Mr. Philip. Just plain and simple, if you are filing a claim on behalf of a client, what do you see when you file a claim about the jurisdiction? How do you confer jurisdiction? Basic points. And whether this case falls within those basic points, whether Oman has a jurisdiction or DIFC has a jurisdiction based on that. The main basic 3 points, what are those according to you?
There are
any civil claim when you file a civil.
There are certain elements that regulate the jurisdiction of a court. One is the subject matter jurisdiction, and the other may be the party's jurisdiction. And in either case, if any is present, the court may exercise jurisdiction. And my contention before this court is that the DIFC court have subject matter jurisdiction because the said contract, which is the subject matter in dispute, has been concluded within the jurisdiction of the DIFC court.
So you are saying it's partially concluded?
I am not saying it's partially concluded. I am saying it has been wholly concluded within the jurisdiction of the DIFC court because the nodes within the DIFC court constitutes the overall network of the clevity. It's just like the clevity platform is located within the jurisdiction of the DIFC court because of the nature of the distributed ledger of the network that the clevity platform is operating.
Okay. Okay, continue.
Thank you, Excellency. The case of, with regards to my first standpoint, which is that the clevity platform and the node located within the DIFC court is a representation of the entire clevity platform. I've explained this earlier. The nature of a distributed ledger will contribute to this. And assuming but not conceding that it is not the overall network of the clevity, the case of current Pipeworks SC versus Barclays Bank decided by the Court of Appeal 2011 to the effect that even if it's just a branch that is located within the DIFC court will still have jurisdiction over this matter. So assuming but not considering it is not the entire platform located within the DIFC, if it's just a branch, the DIFC court will still have jurisdiction over that said branch, so long as the contract was concluded using the said platform and the node is located within the DIFC court, jurisdiction of the DIFC court. On the second standpoint of my argument that there is no clause that was entered by the parties that is prejudicial to the jurisdiction of the DIFC court. The element of default jurisdiction has been highlighted by the Small Claims Tribunal Court in the case of Lucin and Lend, where the court made mention of two elements that will give the DIFC court default jurisdiction. The first element is that the said contract.
Sorry to interruption. I think you were relying on authority of the Small Claims Tribunal. Could you tell us why is that precedent binding on us, if it is binding on us, and what were the facts in that case before stating the legal principles?
And also, counsel, to be fair, you reserved 20 minutes, which was the length of time that Ms. Bashir had. I want to make sure that each party sticks to their time allocation. So could you do that very quickly?
Okay, thank you, Excellency. In the case of Lucin and Lend, the parties entered into a contract and they clearly give the Dubai courts jurisdiction over the matter, not the DIFC courts. And the plaintiff brought his claim before the DIFC courts, and the DIFC court took its time to mention the elements that will give the DIFC court jurisdiction. And the clause that was entered by the parties in the said contract play a vital role in denying the DIFC court jurisdiction, because the DIFC court cannot exercise jurisdiction where the parties entered into a separate clause giving another court jurisdiction, unless that court denies itself of jurisdiction, refuses to exercise jurisdiction before the DIFC court will have jurisdiction under that matter. So in that case, the court took its time to highlight the two elements that will give the DIFC court default jurisdiction. One of the points is that the parties must have concluded the said transaction within the DIFC. The contract must have been concluded within the jurisdiction of the DIFC in line with Article 5A1B of the Judicial Authority Law. And the second element is that there is no clause that was entered by the party that is prejudicial or that gives another court jurisdiction. In such cases, ordinarily, the DIFC courts will have jurisdiction by default over such matters. And relating it to the fact of this case, in paragraph 5 or in paragraph 6 of the moot court problem, it clearly states that the transaction, the disputed trade, was concluded using the Clevity platform. And the Clevity platform, as I have proved before this court, operates fully within the jurisdiction of the DIFC court because it has a node there. And the node is not just an ordinary node. It's a distributed ledger node, which can be rightly be said to contain the entire information within the platform. And it can represent the entire platform within the DIFC. This proves the fact that the contract or the disputed trade before this court was concluded wholly within the jurisdiction of the DIFC court. And as such, this court does not just have a mere jurisdiction. The jurisdiction of the trial court was a default jurisdiction. And as such, the exercise of the jurisdiction by the trial court was right because they were exercising their rightful default jurisdiction over the matter. And with this final submission, it is my prayer before this court that the judgment of the trial court should be, the judgment of the trial court should be declared, and the exercise of jurisdiction by the trial court should be declared by this court as proper and right, and the appeal before this court should be dismissed with cost. And this prayer is contained in page 5 of my skeleton bundle. Thank you, Your Excellency.
Mr. Philip, thank you so much. And my own apologies for mistaking the time available. Ms. Bashir, I think you have the right of reply. And Mr. Philip had a little bit beyond his allotted time. So if you do have points arising from his submission, please could you deal with them by way of reply?
Thank you, Your Honor. In the interest of time, I believe we do have to wrap up the sessions pretty quickly, so I will simply give a short rebuttal. Firstly, using the other counsel's own words of a node witnessing the others. If a node is witnessing, then it is not exactly a party to the contract, and you cannot say that they are the ones who are then forming or accepting the contract. Further, distributed ledgers across systems that we understand replicate and save the identical data across the ledger data. Therefore, it is difficult to say that the contract was wholly and substantially and instrumentally done within the node in the DIFC. Thank you, Your Honors.
Thank you, Ms. Bashir. And Mr. Philip, do you have any response to the reply?
I don't, if I may, Judge Michael,
Sorry.
I don't think the appellant can rebut at this stage. At this stage, we should go directly to the junior counsel. For the
well, I tend to agree because there wasn't anything which called upon a rebuttal. So can we therefore move to the other aspect of the hearing, which is to consider the submissions on mistake, relevant mistake. And again, I turn to the counsel for the appellant.
Yes, hi. Thank you. Good afternoon, Your Honors. I'm Tasneem Ilyas Hussain. I'm the junior appellant representing Mr. Laith Payne. As you accurately pointed out, I'll be dealing with the second issue of whether the first instance court erred in concluding that the purpose of the claim to avoid the disputed trade, it was sufficient for the purpose of satisfying Article 37(1)(a) of the DIFC contract law to show that Ms. Rani showed that a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that the dispute trade was a result of an error. And what I will argue is that there was no mistake at common law or in equity, and I will argue this based on two laws. I'll argue this based on Article 37(1) and Article 37(2) more importantly. So the first thing that I wanted to look at is to look at Article 37(1), where a party may only avoid a contract for mistake if the contract was concluded and the mistake was of importance that a reasonable person in the same situation as the party would have concluded that in all true state of affairs have been known. I think just before I jump into this, I just wanted to make a clarification. If we look at the coin case and look at the coin case as a precedent, the coin case was very clear in telling us in paragraph 97 how algorithm contracts are formed, and the majority opinion found that contract formation took place when an offer was made by one algorithm and accepted by the other, and that the parties had agreed to contract using these specific deterministic algorithms. So I just wanted to clarify that we believe that if we use coin as a reference, the parties were content to abide by what the algorithms meant, and that there was...
Counsel, sorry, what jurisdiction was that? The coin case for what court?
So this was the Singapore court.
Okay.
And it was used
and is this binding on us?
Yes, this was what was used by the court of first instance. So the court of first instance also
in the DFC.
used the coin case, yes, and the DIFC.
And what case was that?
So this is the coin case. It is, let me quote for you the name. It is a
coin case in the
P2
DFC.
LTD
It's a CFI authority.
C2, sorry?
Is it authority of the DFC?
No, but it's common law authority that was referred to in the first instance court in order to show, so this was what was referred to. This was the first instance where they had, because cryptocurrency is such a new arena, so this was a case that they had referred to.
Thank you.
Okay, no problem. So I just want, with regards to mistake, the doctrine of unilateral mistake in common law or in equity, these are the two specific things that I will be looking at with regards to mistake. The former requires proof that the non-mistaken party had actual knowledge of the mistake at the time of the contract, and the latter requires constructive knowledge coupled with an element of unconscionability. The first thing I wanted to look at is unilateral mistake in common law and whether this disputed trade was actually due to mistake. Unilateral mistake requires that one party that has transacted operating under a mistake as to a fundamental term of the contract. And in order for us to look at this, we have to take into consideration the state of the mind of the parties at the point of entering into the contract. And according to, again, Coin 105, the non-mistaken party must have actual knowledge. And actual knowledge here means that they have to have known. So in Coin, the court found that independent of and without knowledge of a mistake, there's no basis for one to rely on the other. So if we actually try and apply this here, we can say that Mr. Payne had no actual knowledge of the mistaken belief or errors of Ms. Rani or the platform Clevity, as they were both asleep during that time. But then this also poses another question, is that this is a little bit different from individuals now that we're using deterministic algorithms. So how then are we going to use, sort of try and make sense of this state of mind of deterministic algorithms? So the answer again comes from the Court of Appeal. And they held that the state of mind was that of the programmer of the algorithm. And they analyzed whether when programming that algorithm, that programmer was doing so with actual or constructive knowledge of the fact that the relevant offer would only ever be accepted by a party operating under such a mistake. And what we'd like to contend here is that Mr. Payne was not did not program his specific algorithm to only operate under such a mistake. And what we want to contend is that this could have been an actual general transaction that occurred, especially given the circumstances, and especially given that this could be an actual scenario that happens in a cryptocurrency world in which demand and supply is dictated by a very volatile cryptocurrency market where people are buying to sell later, where people hoard, and that's why, for example, there could be no sellers. So in these instances, and I will elaborate on this much further later, we want to say that the mind of the programmer was not in order to make sure that whoever is accepting it was operating only under a mistake. It could have been a genuine transaction. More of this will be said later, but I just wanted to talk about the second thing that was discussed with regards to the mind of the programmer, and that was the relative time frame. And what they said is the time frame to assess the knowledge of the programmer is from the point of programming to the point where the relative contract was formed. This is relatively simple in this instance because he was asleep during that time, so the point of time isn't necessarily a big deal here. The bigger deal here is with regards to the first question, about the programmer and their state of mind. And this brings us to the second thing, and of how that's not just a natural transaction, but due to the context of cryptocurrency, this brings us most importantly to the second idea, because Article 37.2 says a party may not avoid a contract if there was either gross negligence or, more importantly, if the mistake relates to a matter in regard to which the risk of mistake was assumed. And this is what we want to argue, is that the mistake here or whether there was actually a mistake or whether this was actually just an assumed risk. we want to clarify that we think that a reasonable trader would have foreseen market developments to occur given the nature of the program that Ms. Razi had made. That not only the things that I had said earlier about how this is an actual scenario in the cryptocurrency world where demand and supply dictate a volatile market, but this is also a bullish market where buyers are overly optimistic about price rises and buy to sell at even higher prices later. Cryptocurrency is considered to be a highly volatile asset that is subject to unpredictable fluctuations in price. Financial experts typically advise against investing more money in cryptocurrency than you're willing to potentially lose. The reason I'm stating all of
Counsel,
this...
that's all very well and good in terms of general principle, but let's relate it back to the present case. Your co-counsel in opening acknowledged that this was a notoriously risky commodity. Both Mr. Payne, your client, and Ms. Rani knew that they were both sophisticated players in this market. So surely when Mr. Payne drafted his or created his program, he created his program with the intention, in certain circumstances such as the present, of making a super profit. He must have created it with that intention because that's what he's done. Isn't that an intention to exploit?
So I think that we have to sort of make a comparison here and a nuance between exploitation and profiting, because in this instance, we feel like, especially given the market and given how individuals within a market and demand and supply, we feel that it is fair for an individual who, when there is, for example, high demand and little supply, to be able to increase the price. I understand what you're saying about being overly exploitative, but I don't think that that's necessarily the intention here. The first thing we'd want to say is, if we look at, for example, the judgment on page 22, paragraph 43, in Coin, the judge said that there's no impropriety. Even if they were opportunistic, it is not considered as something that is sinister. But the second thing that we wanted to say is that in this market, especially in the cryptocurrency market, it is well known that some individuals would buy at a high price to sell at an even higher price. So it isn't necessarily that he was trying to be exploitative, and it was difficult for our learned opponents to show that he was trying to be exploitative. If all he was trying to do is play a market that is known for high prices and is known for individuals in a bullish market to buy at high prices and then sell at even higher prices. So in this
instance, counsel, once again, don't we have to relate what you've just said as a matter of general principle to the particular facts? You say profit should not necessarily be equated with exploitation. That must be right, because that is the whole essence of any capitalist economy around the world. But if you say that a profit of 250 times the market price is not exploitative, is that your case?
So this is exactly what had happened in the Coin case. It is exactly the same. The Ethereum there was also sold at 250 times the price, and the court still saw that it was not their place to interfere in a bad bargain. The judges in that case still said that if you are an experienced, sophisticated person in the market, then you should have, for example, there are several things that she could have done. She could have capped the amount of money that she would allow her algorithm to buy this cryptocurrency at. Ms. Rani could have also, for example, made instances, because it's known as a very monopolistic market, she could have made instances where her algorithm would not, for example, buy if there was only one other person that was selling within the market. So if we look at the Coin case, they had 12 layers of different algorithm trading strategies known as a strategy chain in order for them to sort of deal with all of these sort of different influxes within the market. So then the question here is still, was Ms. Rani just very innocent and naive? I mean, we feel for her, but if you're entering into this type of trade, and if you're entering into this very well-known speculative instance, should she not then have been more active in making sure to protect herself and making sure that her algorithm was much more sophisticated than the algorithm that she presented?
Well, counsel, of course, that's a question, rhetorical or otherwise, and we are here to really determine the facts of this case, is it the case really as follows, that coin is perhaps persuasive but not binding upon us, that there is an equation between profit and exploitation, and it then becomes a matter for this court to determine whether the profit made on the present facts was within reasonable commercial bounds or was exploitative? Is that the question for the court?
Yes, because the thing that we would like to say is that given her algorithm and given the market, even if we take Clevity out of the situation, the algorithm as she had programmed it and as he had programmed it in a specific area would have still bought cryptocurrency from any other trader, not just my client, at any other price, perhaps even more than at 250 plus times, given the way in which it was programmed. So what we are saying is, even if we take out my client and even if we take out Clevity from this equation, her program would still leave her open to such fluctuations within the market.
Counsel, thank you, sir. Thank you.
So I think in this instance, if we really look at Article 37.2, a party may not avoid the contract if the mistake was related to risk. And this is something that we wanted to stress, especially in the cryptocurrency world, especially with more of these instances that are going to start coming up with regards to a lot of these transactions that are made online.
Thank you, Counsel. Apologies for the interruption, but since, of course, as you know, we are under limited time. So I think you have exhaustively addressed paragraph 1A of Article 37, which is about the definition of mistake. Mm-hmm. But I'm interested also in paragraph B, which says that there can be mistake only there can be mistake if the other party had not at the time of the avoidance acted in reliance of the contract. So for you to defeat the other side argument of mistake, you should, I believe you should convince us that your client has acted in reliance of that transaction. So could you guide us to the facts as to what actions of your client represent reliance on the transaction and therefore that the transaction cannot be avoided?
Yes, so if we look at the very nature of the two algorithms, they're almost like a principal-agent sort of relationship. And the idea here is that when Mr. Payne and Ms. Rani created those algorithms and gave them the authority to make these contracts on their behalf, the assumption and what was relied on here by my client is that these contracts are going to be binding. You have an offer, you have acceptance and an intention to be bound, and both of these algorithms will negotiate and then create that contract. That in and of itself creates reliance by my client that this is a successful contract, and he has relied that this contract is something that has worked, like that has basically benefited my client. So the facts of the case do not specify whether this money, he was reliant on this money for any X purpose or anything specific in those instances, but we can tell from the facts of the case that the way in which they created those algorithms was in fact meant that they relied on these algorithms to create these contracts for them.
Thank you, Counsel.
I believe the final thing that I just wanted to mention is this is sort of just like in anticipation of any possible, because we believe that maybe the only other possible avenue is, for example, if she were to look at mistaken equity. But however, even if we were to look at the mistaken equity for Ms. Rani, we believe that mistakes in equity still require some sort of sinister intent or require some sort of inequality on our half. And in this instance, we say that this is just basic economics of demand and supply. And we say that in this instance, it would be unfair to try and, for example, characterize someone who is just playing the market as it is in a very bullish market in order to make profit. This is basic demand and supply. This is basic free market economics. And we believe that in this instance, if an individual is unaware and has not programmed and is not experienced or professional enough, we cannot continue to, for example, allow them to get relief in equity, or else just as a matter of policy, this is going to create a lot of problems in the future.
But Councillor, you're focusing on Ms. Rani's position. Shouldn't we also be focusing on your client's position? And I come back to the test in a mistake in equity. Unconscionable conduct is part and parcel of that test. Why should the court not stand back, look at what's happened, say that a profit of 250 times the going market rate is plainly unconscionable conduct, and find therefore mistake in equity?
Because the idea here is it's because of the nature of the market. 250 times the going rate for us as laymen, and for us as, for example, traders in anything other than cryptocurrency, might seem a little crazy and might seem in this instance as over profiteering. But if you look at the market itself, if you look at the cryptocurrency world, these extreme fluctuations of overvaluing and undervaluing are what basically makes this cryptocurrency function. It is, as we say, quite an unregulated market internationally, and that is the reason why this is very new. But in general, this is the nature of the market, and it's not highly exploitative given the nature of cryptocurrencies around the world, where you could wake up a millionaire, but if you wake up and you've made a loss, then suddenly these highly speculative, almost gambling, become a problem.
Yeah, but this is the very point, isn't it, Council? That this isn't a situation of a good being worth whatever anyone will pay for it in the open market. This is a good on the basis that cryptocurrency is a profit, is property. This is a good which is priced according to a glitch in an algorithm. That's very different from a fair market price, isn't it? And that brings us back to unconscionable conduct, doesn't it?
But again, the first thing here is that, again, this doesn't point to the intention of my client. So even if there was a glitch, it doesn't show that my client programmed his program intentionally to exploit such a glitch. The program just was made in a way where if there is high demand and low supply, the prices will go up. And this is what ended up happening. Devoid of that, if devoid of this glitch, this still would have happened and it still would have occurred. And I think, just again, to reiterate some of the things that we said earlier, is that this is not a very rare circumstances. People hoard currency sometimes, and that's why there are less sellers in the market. People also buy at very high prices and are optimistic about price rises and buy it at a high price because they feel like it's going to continue to rise, and then could have bought it at 250 times the price in order to sell it at an even higher price. And these are all not unconscionable things that could have gone through the mind of our client when they were creating this program.
Council, thank you. Please continue.
I was just going to wrap up and say that's why in this instance we don't feel that there was a mistake in common law or in equity. Thank you.
Council, thank you very much. And Junior Counsel for the respondent, please.
Your Excellency, am I audible?
You are, yes.
Thank you very much, Your Excellency. Entering appearance is P. Usiosefe. Usiosefe is spelled U-S-I-O-S-E-F-E. Oh, I apologize. Can you hear me now, Your Excellency?
Yes, we can.
I can. I don't know about Mr. Ghosh. Mr. Ghosh?
Yeah, now I can hear her. Yeah.
Okay.
All right. Thank you very much, Your Excellencies. I was just spelling my name, U-S-I-O-S-E-F-E with the initial P. And Council will be addressing ground 2 of the moot fact. Now, ground 2 reads that the first instance court erred in concluding that for the purpose of a claim to avoid the disputed trade, it was sufficient for the purpose of satisfying Article 37, Sub 1A of the DIFC contract law that Ms. Razi showed that a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that the disputed trade was the result of an error. Your Excellency, Council will be conversing on 2 standpoints to address this issue. And they are, one, that the elements stipulated in Article 37, Sub 1A of the contract law are present in this case. And secondly, that the normal functioning condition of Clevity platform was non-existent at the time of the transaction, and thus the contract can be voided for mistake. Your Excellency, to buttress this standpoint, counsel relying on statutory and judicial authorities, and they include Article 37, sub 1A of the contract law, Article 3.5 of the Union Principles, the judicial authorities of Bell and Never Brothers, Kotsuya and Hasty, and lastly, Haston and Hazel. Your Excellencies, the citations for these judicial authorities are provided in Council's respondent bundle. Your Excellency, going to the substantive part of my arguments, Council would like to read the provisions of Article 37, sub 1A of the contract law. It states that a party may only avoid a contract for mistake if, when a contract was concluded, the mistake was of such importance that a reasonable man in the same situation as a party would not have concluded at all if the true state of affairs had been known, and A, the other party made the same mistake, or was also mistaken, or caused the mistake, or knew or ought to have known of a mistake, and it was contrary to the reasonable commercial standards of fair dealing to leave the mistaken party in error. Your Excellency, Council would first of all like to state what occurred in the case of Haxton and Hazel. Your Excellency, in that case, it bordered on payment of pension fund, and the plaintiff instituted the action claiming that he was owed about $40,000 as payment, basing his argument on a particular document that had been sent to him by the defendant. But the defendant was able to prove that the $40,000 he saw, or rather over $40,000 actually, they arrived at that sum based on error in calculation. And what was actually due to him was $26,000. Your Excellency, in that case, the court held that the plaintiff could not enforce a mistake. It also took into cognizance that another document had been sent to him having the breakdown of what was due to him. And the sum in that particular document actually was $26,000. Thus, the plaintiff's attempt to institute an action, rather not an attempt, he instituted an action to enforce that particular mistake was wrong. Besides, he was in the position to have known that, seeing the discrepancy in both documents, he would have known that it was a mistake. Your Excellency, in the application of these authorities to the case at hand, I would like to draw the attention of this court to paragraph 4, 5, and 6 of the Moot Fact. Now, it states that Mrs. Razi's program, Alpha, was, she programmed her algorithm to buy at the best available price. Your Excellency, the emphasis is on the best available price. But going to Article 5, we can see that an upgrade occurred which led to a fundamental malfunctioning in the system, such that persons who were legitimately entitled to transact on the Clarity platform were excluded, with the exception of 2 persons who are the parties to this case. Your Excellency, the error led the algorithm of Mrs. Razi to purchase from the appellant's algorithm at the only available price. Your Excellency, Council would like to draw a distinction between what is the best available price and only available price. Best is a superlative form of good. You see the phrase good, better, best. It occurs in cases of comparison. Council's assertion is that there was no room, due to the error that occurred on the system, for the algorithm to make a choice as to what was the best available price at that particular point in time. Rather, what the transaction that occurred was a purchase based on the only available price, and all this flows from the fundamental malfunctioning of the system. Council would also like to assert that the algorithm of the appellant in this case was mistaken as to the actual situation of things. Now, paragraph 4 states that beta was programmed to sell at a highly inflated price when no other user was offering. Your Excellency, the actual position of things as at the time of this contract was not a case of no other person offering. It was a case of a fundamental malfunction and excluded persons who were legitimately entitled to offer to make purchases from accessing the platform. First, the algorithm initiated the high inflation and the highly inflated price factor, thinking that there was no offer. Rather, all this was due to a fundamental breakdown in the normal functioning condition
Okay,
of
Council,
the
apologies
Clarity
for
platform.
the interruption, but just to
No
go
problem, Your
to the
Excellency.
point,
Yes.
I think it is undisputed here that there was a problem with the platform, right? There was some malfunctioning, and in the platform, there was an error probably in the programming. But the question here is why we should decide that your client was mistaken. I mean, the moment, and I refer here to the arguments presented by counsel for the appellant, that this is a high risk product, and at the point in which somebody decides to invest with Clarity, to use Clarity, or to invest in this type of security, they accept the risk. They accept the risk. There might be fluctuations in the price of the commodity. So why is that a mistake? I mean, it's part of the game. They accepted the risk. Your client accepted the risk.
Your Excellency, counsel's argument is that, of course, there are risks inherent in cryptocurrency transactions, but this particular malfunctioning of the Clarity platform, the platform is the basis for everything. Without this platform, no transaction would hold. So the fundamental malfunctioning of the Clarity platform is what led to this transaction that occurred, this disputed trade. So it isn't particularly a case of assuming risk for inflation in prices of cryptocurrency, but can we say that she assumed the risk that one day the platform would break down in such a way that would exclude persons who ought to legitimately transact on this platform from doing so, but it would leave only 2 persons on the platform, and her algorithm would end up purchasing at the only available price rather than the best available price? Because I'm sure when she was programming this algorithm, she imagined an actual market scenario with a number of persons offering, a number of persons purchasing. Besides, that was the contractual agreement. There were to be a person that had up to $50,000 US would be allowed to transact on the platform. But on this particular day, it was persons that had up to $200,000 US that were on the platform. So we can't separate the absence of a normal functioning condition of the platform from the cryptocurrency transaction, Your Excellency.
Counsel, am I right that you identify the mistake as being the malfunction of the Clarity platform?
Your Excellency, counsel is asserting that the purchase was due to the malfunctioning of the system. The mistake was in not knowing that there was a malfunctioning, leading to the only offeror in this case was now the Apple, rather than purchasing from a normal system would be a number of persons, of course, available, a number of persons to choose and pick which or what the best available price as at the time a particular transaction was being made. But unfortunately, due to this error, only 1 person was available on the platform. Only 1 price was available on the platform. Rather than purchasing at the best available price, what occurred was a purchase at the only available price. Besides, the high inflated price of the other party was also mistaken. Yes, Your Excellency.
Well, I want to move away. I accept the facts and I understand the facts of this particular case. But what I want to do is move away from the facts and look at the law, just the underlying principle. Is it not the case that there has to be a mistake about a contractual term rather than the mistake arising from external circumstances, namely the glitch which was introduced not by claimant or respondent, not by appellant or respondent, but by a third party, namely Clarity? So what I'm looking at is the law on mistake. Does mistake in law need to be a mistake as to a term of the contract?
Yes, Your Excellency. It is with regards to a term of the contract. But if you refer to paragraph 1 of the statement of fact, you will see that a condition of trading was that users must maintain at least $50,000 US. But due to this error, it was persons who had 200,000 US dollars that were allowed to transact on the platform. This was not the normal, it was not a function of the normal contracting terms of the agreement. There were also having persons who had up to 50,000 US dollars to transact on the platform. And such persons would have been available for the party to make an option of the best available price. Thus, Your Excellency, it was necessary that these persons be on the platform. The number of persons is part of the contractual term. It's like an implied term. It's a condition of trading, as is stated in paragraph 1 of the statement, the moot fact, Your Excellency.
Thank you, Counsel.
All right, Your Excellency, I'll be moving to my second stand. Before I do that, I would like to state that as provided in the introduction of Article 37 sub 1, A provides that a mistake occurred, but the introduction states that with a reasonable man, in the same situation as a party, which would be the respondent in this case, would such a person have concluded it knowing the true state of affairs? Your Excellency, I posit that it is quite visible to the blind and even audible to the deaf that no reasonable man, knowing that a fundamental malfunctioning of the system had occurred, would have proceeded to continue the disputed trade. Thus, all the elements provided in Article 37 of the contract law, which is a fundamental statute regulating this particular dispute, are contained in the respondent's plea. Thus, this particular disputed trade can be void for mistake. Now, going to the second standpoint, that the normal functioning condition of the clarity platform was no longer existent. And before Council proceeds, Council would like to state that the breakdown in the functioning of the clarity platform should not be separated from the transactions that arose, as it is the foundation for the transactions that took place. Without the platform, there would be no cryptocurrency transaction in this case. Now, Council is asserting that the platform is pertinent as a subject matter, and for the fact that the normal functioning condition of the platform was no longer existent, the contract can be voided for mistake. Council is relying on the cases of Bell and Lever Brothers and Koturi and Hasty. Now, in Koturi and Hasty, the facts are there was a transaction for a cargo of corn. Now, this cargo of corn was in transit from the Mediterranean to England at the time. But unfortunately, the cargo of corn perished and was disposed of unknown to the parties before the contract was concluded. But the plaintiff sought and initiated an action to enforce consideration for the already damaged and disposed cargo of corn, stating that title had already been transferred. But the court held that the contract was void for mistake because the subject matter of the transaction was at the material time no longer existent. This particular principle was also upheld in the case of Bell and Lever Brothers. Your Excellency, all my counsel is simply stating for this particular standpoint is that the foundation for the transaction, the normal functioning of this particular foundation, which is the clarity platform, was no longer existent due to the fundamental malfunctioning that came about from the upgrade. Thus, this particular contract can be voided for mistake. I wouldn't want to believe that it is the intention of the appellant to take advantage of the fundamental malfunctioning to exploit the situation and sell at a highly inflated price. I believe that
sorry, Counsel, isn't this case rather different from the case of Bell and Lever Brothers and Couturier and Hasty, in that just looking at the facts that you summarize of Couturier and Hasty in paragraph 16 of your skeleton argument, there the cargo of corn simply didn't exist. So therefore what the parties were agreeing upon had no existence at all. Whereas here, Cleverty's platform did exist and it was operative. It was just operative in a way which was highly disadvantageous so far as one party was concerned, highly advantageous so far as another party was concerned. So are we actually comparing like, with Couturier and Hasty on the one hand, where there just wasn't a cargo of corn, and this situation where Cleverty did exist? It can't be said that it was non-existent. It was just that there was a glitch in the system.
Your Excellency, Council is asserting that the normal functioning condition of a platform was not extant at the time the transaction was made. And this platform is the foundation for whatever cryptocurrency transaction that occurred in especially this particular disputed trade. So the fact that this particular the foundation was not functioning properly as it ought to, it can be asserted that it was non-existent as at the time of the contract, Your Excellency.
Thank you, Counsel.
All right. Your Excellency, I would like to submit that all the elements stipulated by the primary statutes governing this particular contract are provided in this particular case. And thus, this case should be voided. The court should uphold the judgment of a trial court and dismiss this particular appeal. Besides, I noticed that counsels on the opposing side made no prayer as to what they wanted the court to do exactly. The court is not the Father Christmas that gives whatever it is it feels. It gives only what counsels urge it to give. Thus, the court should please dismiss this appeal. Besides, consideration should be taken as to technological developments and the mandate of the DIFC court, which is to promote digital financial transactions. Enforcing a fundamentally erroneous contract would dissuade persons from participating in cryptocurrency transactions using automated algorithm in the future. So the future of technology, the future of cryptocurrency transactions should please be protected by the courts. Council thanks the Excellencies for listening to counsel.
Counsel, thank you very much indeed. And I think that there is an opportunity for junior counsel for the appellant to rebut.
Yes, thank you so much, Your Honor. I think it's just two brief points of rebuttal that we want to make. I think the first point of rebuttal that we'd like to make is that our learned friends spent a lot of their time focusing the case on a fundamental mistake on behalf of a malfunction of Cleverty and not necessarily according to the law, Article 37(1), which is in regards to Ms. Rani's unilateral mistake. So this is the first thing that we want to point out. But the second thing that we wanted to point out is if, assuming and giving them credit that it was Ms. Rani's unilateral mistake, we'd still like to point you to Article 37(2) and question whether this was necessarily a mistake or was necessarily an assumed risk, given that even without the presence of the glitch of Cleverty, her algorithm in such a market like the cryptocurrency market would have still bought at highly inflated rates if there was only a single buyer, our client or otherwise.
Counsel, thank you very much. May I turn to my colleagues on the bench? We have been interventionists during the course of the hearing, and certainly as far as I'm concerned, I've asked the questions that I would want to have asked during the hearing. But colleagues, do you have any further questions of any of the counsel?
No, I don't have.
Mr. Kare?
No, nothing from me.
Thank you so much. Counsel, may I turn to you within the confines and constraints of the rules of the competition? Have you had an opportunity to present the arguments that you would wish to do so to this court?
Yes, Your Honor.
Yes, Excellency.
Thank you so much. In those circumstances, it will come as absolutely no surprise to you that the Court of Appeal is not in a position to render a judgment immediately. We cannot proceed to an extempore judgment. We will therefore reserve our judgment, which will be handed down in draft form for correction of typographical errors by counsel in the usual way. It only remains for me to thank each and every counsel very much for the helpful and constructive submissions which you've addressed to the court. We are extremely grateful, and I think, subject to anything that anyone else may say, that draws the formal oral hearing of this appeal to a close. Colleagues on the bench, are you happy that we should close the oral hearing?
Yes.
Yes, Sam. I believe in the spirit of moot courts. If you agree, I think will be helpful for the teams to receive some informal feedback from us.
That's right, and certainly when I've been sitting on previous moot courts in this instance, where if we go back to our retiring room, it's rather difficult to convene the court again. So to avoid that, and if counsel is happy, I am happy to extend proceedings whilst we're all together, so that my colleagues can begin with feedback immediately, should either of you or both of you see fit. Mr. Kare, you have the floor at the moment, so why don't you start?
Thank you. Okay, so thank you, everyone. I believe you already had a few rounds yesterday, so you had a chance to rehearse your arguments, and you could know the record very well. Well done. I think this was a very helpful experience for you. I have a general remark, I think, for everyone. So the DSC court is a common law jurisdiction, but it's a very particular one because most of the laws are written. It operates through statutes. So sometimes the DSC court refers to common law authority, particularly authorities from England. But what really is commanding here are the statutes. So always start from the statutes on jurisdiction. So the way I would expect an argument raised by you is starting from the statute, from Article 5, what part of Article 5 in jurisdiction you're relying on. And here, Article 37, again, first you should try to recall what is the test? What is the test that should be passed for Article 37 to apply? And to the extent that Article 37 is not clear, you can refer to authorities. And I'm sorry to say, nobody here referred to the unidroit principles, because that's where Article 37 is coming from. The DSC contract law is very much a mixed system of contract law, because it comes from the unidroit principles, which are again a synthesis of common law and civil law principles. So if you start from the authorities, and often again, when you refer to authorities, often you have not stated from what court, what jurisdiction, because that's important, because if it's authority from here for the DSC, that is binding. If it's not DSC, it's not binding. Can even be the English Supreme Court, it's not binding. So start from the authorities, and that's and another remark. Again, in a court like the DSC court, you would expect to refer to your skeleton, to your arguments. So and I've seen rarely you doing that. So because you should help the court following your arguments, referring to the record. Thank you.
Thank you. Mr. Ghosh?
Yes, I mean, apart from the merits, which will be decided later, but it takes courage to stand before a judge and argue any matter, whether it's simple matter or complex. So congratulations to all of you. So keep trying your best to keep your poise while arguing the cases. Winning or losing is, of course, is part of it. So as my friend and colleague, Mr. Kerr, said that unidroit principles have not been adhered to, not been discussed at all. That's also true. But anyways, congratulations to keep going. I'd like to see you as some brilliant lawyers in future, whether in DIFC or any other jurisdiction. So that's it.
Thank you
very much, Mr. Ghosh. Certainly, I would echo the congratulations of both of my colleagues. I thought it was extremely interesting. I think you've all done an enormous amount of research. They were all extremely good performances in the context of a moot. So you should feel rightly proud, each and every one of you, of your presentation and all of the work, the hard work that has gone into this. I think on the unidroit principles, I was just looking back at the memorials, and certainly so far as the University of Benin is concerned, I do see that the unidroit principles were referred to in paragraph 19 of your skeleton argument, and you did invite us to have regard to the skeleton argument. So I think that for the record, we should just put that on record. The only other thing I would say is that accepting the constraints of time in a moot, if you can speak at a relatively measured pace, so slow down beyond your usual conversational pace, that is probably going to be helpful, because quality of submissions is what's important rather than quantity in terms of words spoken in a particular given time. I think that we usually speak at something like 150 words a minute. And what you should be doing is slowing it down to about 110 or 120 words a minute. So you should be reducing the rate of speech by, you should be slowing down by somewhere around about 15–20%. That's the only broad guidance that I would give. I think I speak on behalf of my colleagues in saying that in the context of a moot, we have to be in the position of judges. So there is a certain court hierarchy, but outside the moot itself, there is absolutely no hierarchy at all. We are enormously respectful of the amount of work you've done. And if there's any hierarchy, you're higher up than we are. So please feel free to follow up with each and any one of us should you see fit. We wish you a very successful career ahead of you. You all four have great prospects, and we look forward to following them with great interest. So thank you very much.
Your Excellency, if I may, when would we be getting the results of this appearance?
Well, in terms of a judgment, the court is extremely slow in delivering judgments in written form. In terms of the decision, on the moot basis, who wins, it's a very close run thing. I need to confer, we need to confer all together. I think that we need to get the responses back within 15 minutes if we can. So we feed our responses into the DIFC, Ms. Sumo, and she will then inform the parties administratively. I can't take it any further than that. I can't give you a specific time frame. We look, we decide, we put in our response to the DIFC, and indeed I need to check the rules. It may be that we each mark separately.
That's
and
correct.
Then the marks are added up by the administrative team. So even we will not know, because we're not privy to each other's marks, we will not know who has won. It will be a matter of arithmetic for the DIFC.
Thank you very much, Your Excellency. I was graciously obliged.
Thank you.
Thank you.
Excellent.
Shall we the judges' room for deliberation?
We're going to the judges' room for deliberations. Thank you all very much. We should leave this meeting and reconvene in the judges' room. Thank you all again.
Thank you.
Thank you, Excellency.
Thank you.
Hi, Sugandha. Is this over now, session?
Yeah, the session is over. Judges have just left it like a few seconds back. So
Okay.
I am just ending the meeting and closing this case.
Okay, thank you.
So the other participants, I think there are 2 more participants, so I guess they can also leave.
Yeah. Hi,
I
Tasneem.
think.
I think the session is over, so you can leave now. Okay, thanks, Sugandha. You can end the meeting.
Okay.